This meeting is
Kayla.
called to order. Lee, will you call the roll?
Kayla,
Here.
Jim,
Here.
Greg,
Here.
Lee, here, Mary Ann,
Here.
Ross,
Here.
and Phil.
Here.
Okay. So the December 9th meeting minutes have been dispersed to everyone. We've all had a chance to look at them. Yeah, are there any corrections to those minutes that anyone wanted to make? All right, if there are no corrections, we'll go ahead and approve those minutes. Let's go ahead and approve the agenda for this evening. So we have the president's report, then we have treasurer's report, architectural committee report, Aloha committee report, maintenance manager report, and then Greg, do we know who's doing the neighborhood watch report? Are you going to do that?
Yeah, I can do it.
Okay.
Is Richard on? Maybe Richard can do it if he doesn't mind.
Richard, would you be willing to do that?
I don't really have the neighborhood watch report, so that should be
Oh.
Greg.
Okay, I'll do it. No problem.
All right. And then in our general orders for tonight, we have the 2022 apron policy coming up. Our vetting of CCNR compliance for candidates. And then also discussion about a possible special assessment. And then there are other things that are going to be pretty much in the reports, a lot of it in Greg's report tonight. So so we'll go ahead and approve this agenda. Are there any corrections or anything anybody wants to add to the agenda?
Kayla, not to the agenda, excuse me, but I was just curious if we couldn't have just a brief, some kind of January minutes report just for paperwork file situation. I don't know. Does that make sense?
Okay,
You know what I'm saying? Just what we did briefly.
okay.
Thank you.
Well, we'll have to approve that, I guess, next month.
Okay, thank you.
Okay, thank you for that. All right, so if there nothing to be added to the agenda, we'll go ahead and approve the agenda as it is. So let's start off with the president's report. Obviously, we were hoping for a ruling last week, some kind of ruling from the judge. And Judge Nakamoto has not yet issued a written ruling from the January 19th hearing. I guess shortly means a different thing for all of us. Therefore, as there's not been a ruling rendered, no date for the election has been set. Also, as far as historical records go, the minutes from 1976 through 1982 have been posted to the LCA website. There are more minutes to come. That way it allows all members to be able to read through those if they'd like. Also, a court ruling from 1986 has been posted as well. And I've also composed a table of historical LCA bylaw changes. They have also been posted to the website. So that's my report. Greg, can you give us the treasurer's report?
Okay. Mine's not too happy. First of all, I'm going to address the SBA loan first. There is no SBA loan. Okay, I'd like to read from the minutes of August 2020. The previous board stated, September 2018, the LCA board applied for a SBA disaster loan and was subsequently approved for a loan of $358,100 at 2.5% interest. That part is correct. part that's not right is the loan was applied for repairs to the building. Had nothing to do with roads. And that stuff sat there all this time until I got closing documents in October, and no one looked at them. Also in that August 2020 board meeting, the board announced we have now reached the end of the maximum time period to keep this loan. As a result, LCA has now applied for an initial minimum 25,000 disbursement to keep this larger loan option available to the LCA. That is a complete lie. They could not do anything on this loan. All this was another piece of crap coming from them. I'm sorry, but that's all I've done since I got back on the board is correct messes that those people made. The very first thing in the closing documents that freaked me out when I got them in October, very first thing says you must issue a special assessment for the total amount of the loan, and it has to be secured before you get even 1 cent. That was not done. They did nothing. Here's the file. There are 25 plus Post-it notes on here of action items that were supposed to have been taken by the previous board. They did none of them. Not one thing is done. I worked with the legal department for about a month and a half trying to get them to agree. I explained to them, instead of the special assessment, the board had instead increased the dues considerably to cover it. And I tried to give them as much information I could to support that. And I thought I was making headway with the legal department then. Well, unfortunately, she decided to retire. The new guy came on and he just absolutely refused. He said, you don't dictate terms to us. You either take our terms or the loan is canceled. So we have no loan with SBA. So my next step from there, I went to Territorial and I went to Bank of Hawaii and requested a loan. Territorial was not interested in giving us a loan. Bank of Hawaii was. However, the terms they came back with are not acceptable. The interest rate was not bad, but if we paid back early, there was major penalty, and we would have to secure all the money that we've got there anyways, plus the Territorial accounts. We'd have to secure those until the loan was done anyway. So there was no advantage to doing that one either. So at this point, my suggestion is that we take, right now we have in the 2 Territorial accounts and the reserve account in the Bank of Hawaii, we have $307,500 roughly. We owe Grover $344,800.03. So I'm suggesting we take the money out of those accounts, take the difference out of our checking. We've already started getting money in from this year's assessment for the $37,300 to pay off Glover. And I tell you, things that come up in this, I just.
Greg, what was that? What was that last number
Which one was that,
that
Lee?
we owed?
The total for
What
Glover?
was the last number we owed?
We owe Glover
Yeah.
$344,800.03.
Okay, thank you.
You got the amount for the reserve and everything?
3075.
Yeah, and that's approximately because we have to pay a penalty for early withdrawal, but we'll lose 6 months interest. And then the balance of $37,300.03 to come out of the regular checking account.
Greg, are we correct to assume that the first part of the loan or the payment was made by Malama Opuna?
Yes, that's history. That's done.
Okay. Thank you.
And Glover has been very patient with us. I've explained to them, and Keola's explained to them we were working on trying to get a loan, and that's fallen through. So we told them we would hope to be able to pay soon. So I guess my motion at this point would be to move ahead and take the money out of our reserve accounts and the balance out of our checking account and pay our bill.
That's good, Greg.
I'll second that motion. Can you restate it for me?
I move that we take the money out of our 2 territorial accounts and the reserve fund at Bank of Hawaii and the balance out of our checking account to pay the bill to Glover.
Okay. Lee, will you go ahead and do a roll call vote?
All right. Paola,
Yes.
Jim,
Yes.
Greg,
Yes.
Lee, yes. Mary Ann,
Yes,
Ross,
You're muted.
Yes.
Oh, there you go.
Yes.
Phil,
Yes.
Okay, the motion's been approved. Go ahead and do that.
Okay, thank you. Okay, the other thing, the financials are posted on the website. But we also have finally we have an invoice from our attorney in the amount of $17,234.55. This is from the beginning, which is from April 12th through the end of November. So we still, that's as far as this goes. So $17,234.55.
is that American?
What's that?
Say that again, Lee.
Is that American?
Oh,
That was a joke.
I hope so, because I think it's worse if it goes the other way.
Difference in dollars.
I'd like to
Greg,
make a
this-
motion that we go ahead and pay this bill. I mean, this has been outstanding. We've been waiting for this for a long
I
time.
have some comments in a discussion. I have sent a copy to every member of the board, and it's itemized here on this sheet of paper. And there are clearly some items on here that date back all the way to April, as Greg said, but they're specifically related to the lawsuit. Some items, not all of them. And so I've asked all the members of the board to go through and itemize what they think. And because we may have different opinions about which ones are valid and not, to subtract the ones that are clearly related to the lawsuit, because in point of fact, until 9 a.m. on August 18th, when the judge ruled that LCA became responsible for the lawsuit, those expenses were not to apply to the LCA. And so my position is it's unfair to have the LCA pay for some items that are itemized here that are not the business of LCA, but rather the plaintiffs in the lawsuit prior to the judges assigning LCA as the plaintiff. So hopefully in executive session, we can go through those items and have a reduction. It may be a few hundred, it could be as much as a couple $1,000s. That's the amount that I'm willing to approve.
Jim, I explained to you and Kim explained to you also that there's some items in there. We had Keola review them to make sure, and he agreed that everything that was on there was to be charged to LCA.
Well, unfortunately, Keola is hugely compromised in as much as he's the former plaintiff.
Well, that's your opinion, okay? I know how you mistrust most of the other people on the board, so.
Well, it's a very simple issue. We can do this in executive session and go through. If it turns out to be 17,000, great. If it doesn't, then we should adjust.
Whatever.
okay.
Jim, what's your problem with it? Give
I
me a
have
specific.
I have 14 items that I've marked. some of which maybe you and others would say those are okay, but specifically, legal research regarding privilege of former director. That sounds to me like it's an issue related to the lawsuit. Review and analyze
All
letters
right,
from,
hey, Jim, you're reading stuff that's part of, that's privileged information. So.
that's why I said we can do this in executive session.
Yes,
We can approve, if Greg wants to make this motion, approve to pay the agreed to amount once the board goes through this. That's all I've asked them to do.
we'll go ahead and, if everyone's fine, we'll go ahead and go into executive session to discuss whatever discrepancies that Jim feels there are.
Keola, this is Phil Denny.
Yes, Phil.
If I may ask a quick question, how could any of this be privileged? We're all plaintiffs, all of us. We have a right to this information because we're plaintiffs. There's no privilege here. And
That's
this
not
is
necessarily
private.
true, Phil. Because that was the same reason they gave me for not, I asked for legal invoices before as a member for the things that the LCA was involved in, and that was the same reason they gave me, and it was considered privileged information. So therefore, we can go ahead and address this in executive session.
Again, who is it privileged from? Who is it? Who can't see it? I mean, I don't understand.
Okay, well, let's just take a roll call vote. Those who, let's go ahead.
There's not a motion on the floor.
I move that we go ahead and deal with this in executive session.
I made a motion and it went right past it. I made a motion to pay this invoice.
That's right, you did. That's right, you did. So we have to address Greg's motion first. So,
All right. 17,243.55.
17,234.55.
34. Sorry.
My position is we have a fiduciary responsibility to protect the assets of the LCA at all times, all 7 of us. And if in fact any of these items turn out to be applicable to the former plaintiffs, we would be remiss in our duties if we agree to pay all this. I just want to put that on the record. So anybody that says let's pay without a review, based on Greg's motion, is possibly committing fiduciary fraud,
Oh,
period.
give me a break.
Well, then let's go through them one by one. What are you so scared of?
Let's go
because
ahead.
it
and
is
get the
privileged
vote.
information.
We'll do it in executive session. I'm not afraid of
That's all
anything.
I
Okay,
asked
so
for.
will you withdraw your motion then, Greg?
Yes, I'll withdraw.
Okay, and I move that we take this up in executive session and decide on it there.
Thank you.
Okay, all those in favor, we'll do a roll call vote. Then we do this in executive session. Go ahead,
Keola,
Lee. Yes,
Jim.
If you said Jim, yes,
Jim,
yes,
Greg,
Yes.
Lee, yes. Mary Ann,
Yes,
Ross,
Yes,
Phil,
Yes.
who else did he need to get? I don't know if he went out.
I voted yes. I was the
I
last one.
know, I'm just wondering if Lee went out. Did you get everyone?
no, I'm fine.
Oh, okay, you got everyone,
Yes.
Lee?
Yeah, pass.
Okay. All right, Greg, do you have any more?
Nope, that's it.
What about as far as the candidates are concerned, as far as good standing?
As far as being current in dues, yes. They're
All of
okay.
them?
Yes.
Okay. All right, anything else for the treasurer's report?
No.
Okay, Ross, you have anything as for architectural committee report?
I have some plans to approve. And I'm gonna need to either get a local board member to go over them because it requires 2 signatures. Other than that, I have something on the vetting of candidates.
Okay, and we'll bring that up later. Under general orders.
Okay.
Is that all right?
That's fine.
Okay, anything else, Ross?
Nope.
Okay, thank you. Mary Ann, anything for the Aloha Committee report?
Yeah, just briefly, it was a good turnout. I really enjoyed it, but what I realized that we still didn't really reach the new homeowners as much as I'd hoped we would. We had a few come back, which was really nice. And so I think when we choose to do it again, with Aloha Committee, they've been great, always there to help me. But perhaps send a group email from the LCA, because to me, it's about meeting and greeting all our neighbors, not just the new, but helping to bring, old and new together. So that's it.
Okay.
I think that's it.
Michael, good to see you. You have a maintenance manager report for us this evening? You're muted.
Hello.
Yes.
Yeah, so for this month, I'm currently doing the monthly shoulder mow right now. I'm actually have one more section, the upper Malama, to take care of tomorrow. So I'm gonna finish that. Hopefully the weather holds up. Since our last meeting, I replaced all garage lights. They was all going bad, so I replaced all 4-foot LEDs. Also, I have changed 5 speed limit signs. Also, resprayed the poles. I'm still currently working on the stop signs, but they're out of stock still yet as we speak. I have fixed one of our exercise equipments today. I finally got it done. It was down for over a year. I finally got that repaired and also reinstalled. So that's gonna be back up and going. Our sidearm, I finally got back with them yesterday. They just finished it up. As they were testing it, they found another worn pin basically on the Alamo sidearm itself. So I told them, since it's there, go ahead and replace it already, because I don't want to go back and forth 6 months from now, a year from now. So they weren't clear on how long this will take to get this pin in from Alamo, but that's basically where it stands so far. But they know that I really need it back now, so they're gonna try their hardest to try and work with their employees, whoever's bringing the parts in, to get it in quicker and get it back to me as soon as possible.
Okay.
Yeah.
Do you have a new estimate of the total cost?
Right now, I have to go in. I might go in on Monday because they're gonna have a written one out for me. Then I'll give it to the board. You guys can see where it's at for now.
Okay. So just to let you know, we have a member that I need you to go check out some road.
Yeah, I got the email from Kim today. I went ahead and looked at it. That's on the south side of Kumukahi, dead end side. The road is sinking there. Yeah.
How bad is it?
Oh,
It's actually pretty bad. It's between 10 to 15 feet wide, and there's like a hole on the opposite side of the road.
oh. At the dead end, Michael.
Huh?
At the dead end part, yeah?
Yeah. With the
Oh,
dead
I
end.
can drive down there. I now I get where it's at. 'Cause I
Right, yeah.
Yeah, okay.
Yeah,
That particular sinkhole lava tube has been going for years. It started on the property with all the palm trees and has continually moved forward. The sinkhole has been there pre-eruption, but it's all part of it. It's one continuous
Yeah, it's like a long channel there. Yeah.
collapsing.
Yeah, but it is.
Can it be filled in, Michael?
The only way to proper fill it in, we're gonna have to remove that section of road and basically put material back and asphalt over it again. That's the only way we could fix it. It's basically the same concept as we did on Kupono, where the police were. That's basically what's happening.
We just
Okay.
not drive down there, fence it off?
Put plates over it? Could we put plates like we did on Capono, like they've done on 130?
Yeah, we could. Yeah,
Because it's not a high traffic, it's just a dead end. It's very, very
right,
short.
right. Yeah,
But they do use that side gate.
yeah, because there's a side gate, I guess that the owner that has those properties right there, they've been using that back side gate. So I guess they're going over it now as I saw.
Right. Well, as I
Yeah.
say, maybe we could just get plates and put over it
Right, yeah,
as
that
opposed
would
to.
work. Yeah, because the distance is basically between 10 feet and 15 feet. So yeah, that would work.
Because with our road budget now, I don't think we have extra money for.
Right.
extra. Not right now.
Yeah.
Okay, so maybe we can kind of come up with a solution for that in the next couple of days or something. The plate idea sounds like a good idea.
Okay.
Can we keep communicating on that, board members? As far
Yeah.
as how to rectify that?
Sure.
Okay. You got anything else, Michael?
That's it.
I have a question. Paola,
Yes.
if we as a board decide plates will fix the problem because it would seem to be convenient, does it have to be acceptable to the landowner or can it just be our decision?
Well, it would essentially be our decision because, we're supposed to take care of those roads.
Yeah.
And right now, like Ross pointed out, we're as far as what happened with the SBA loan and everything, yeah, we're kind of in a tight spot right now.
Yeah, no, I agree. I just want to make sure that we as a board agree. I think the plates are a good idea, assuming it's less money. And by the way, as Ross pointed out, that little tube goes through the property. So it's not only on both sides of the street, it actually runs through and they've got kind of a creek mechanism with bridges over it. So it's going to be there, but I like the plate idea as long as it's less money.
Has to be less money.
So we'll look into that, see if that might work. All right.
Just
And if
one
that's
question,
not a
to
solution. We'll have to come up with something else.
Keola.
Yes.
I just wanted to say under maintenance report here, Janet Morrow has donated a wood chipper. And I talked with Michael about it, but I think he needs help loading it. I don't know. Anyway, I'm just putting that out there. It was a donation, I think, very nice donation, and Michael seemed to think it would be useful.
Okay.
Is it a mulcher or wood chipper?
Thank-
Chipper, I believe, yeah.
How big a diameter does it chip of limbs and stuff? Oh, she's going 3 inches.
And where would we store it, Michael?
All right, thank you, Jan.
Oh, we have room in here. It's not, yeah.
Okay. Yeah, thank you. All right, is that all you have, Michael?
Yep, that's it.
Okay, Greg, you want to go ahead with the neighborhood watch report?
Okay, the good news is the vehicles on the Malama property near Onaloa, most of them have been moved. I'm not sure where they went to. They may have gone down the side driveway by the house. I'm not sure, but at least I think there was only 2 vehicles in front today when I went by. There was a raid at Luana and Malama a week or so ago. I don't know that they got anything. I know that there was a couple of people arrested and they've been released. So that's about all I know about that.
They've already been released.
Yep. They kept one guy because for 48 hours because they wanted to make sure there wasn't something they could charge him with. I guess they couldn't, so I just don't understand. The place is a disaster. Ross, do you know, was there ever a letter sent to the property owner about all the cars and everything on the property?
No, that's one where the only thing that we had was dog report. And so all of those known ones where the files were taken, they're just in limbo because I have no idea what was done. Apparently things have been done, but no. And the cars were taken down. The other day, they were bulldozing them down that side driveway to the back of the property.
Oh, so that's where they went then. No, but the one I'm talking about is the one at Luana and Malama. Libby's house.
No, because there was no real CCNR violation. I addressed that one because one of the neighbors was complaining that it was CCNRs, and without going on the property or doing an inspection, was a permitted house. I mean, it was for real. So there was nothing that CCNRs could really do on it.
But I mean, there's plenty of junk cars on there now. Can we address that?
If there are, yeah, we could probably, if there's visible junk cars, we can, yes.
There is, and there's some that aren't visible. From what I understand, there's some shoved into the bushes.
Right.
I warned Libby a long time ago. I told her you need to take care of that problem, and it just gets worse. So I did take a picture today when I was on patrol. I'll send it to you.
Okay.
I just took it from inside my car when I was driving through, but at least you can see all the junk. One of the cars is actually partway on the road. With a sign, keep out.
That's new, because one of the neighbors had filed a written complaint, and I actually went and checked it out when they did that. And I responded back that there was nothing that we could do. From what I could see from the street, there was nothing that I could do anything about.
Okay, I'll send you that picture. It's
Right.
not the best, but at least you can see the junk there.
Okay.
That's it.
That's it for neighborhood watch. All right. Okay, so moving on to unfinished business and general orders. First thing up is 2022 apron policy. I know we proposed a policy back in December. In light of some new information that are found in the archives, or say records of the LCA, found some more supporting court documents that actually support an apron policy. So was everyone able to look at it?
Yes.
Let me see if I can pull it up here.
What are we talking?
Oh, sorry. I'm just gonna see if I can pull it up so we can read it here. Just give me a second.
Kayla, could I ask a couple of questions while you're doing that, please? This is Phil
Sure.
Denny.
Sure.
First of all, my objections are well known that, as I've said before, in my opinion, I think this is improperly amending the CCNRs. The other questions I have are basically about the specifications. I noticed that there's no specifications for the strength of the concrete. As you know, concrete comes in a variety of strengths depending on how much mortar is in the mix. That's not addressed. Secondly, that there is no requirement or specification for reinforcement. As you may know, a 9-yard concrete truck weighs somewhere north of 60,000 pounds, and putting that over a 4-inch piece of unreinforced concrete, I don't think meets the goals of this. Thirdly, the initial policy said that the apron had to be at the same elevation at the edge of the road, but I would point out that the road is crowned to facilitate drainage. And I think the policy should, if it's going to be adopted, should take into account preservation of the drainage, which makes Michael's job of mowing the side of the easement much easier. The only other comment I would have is I would point out in reviewing the 1986 case on which you rely, the court was told and presumed that the LCA was the owner of the roads. And as we know now, that's not true. Whether or not that would change the court's opinion as to the LCA's right to require an apron is unknown. But I think all of those things ought to be considered. Thank you.
Okay, so that was part of the debate, but let me put forth the motion first. So I move that that we approve this 2022 driveway apron policy. And so Phil's spoken as far as the floor is open for debate. And so we've heard from Phil.
I have a question.
Sure.
I think, if I understood what Phil said, that he perceives it as being a modification of the CCNRs, which, as we all know, requires 75% vote. I think the wording that I read said it's a clarification. I don't know what that distinction would be, but can we do this via a bylaws change, or does it have to be a clarification of the CCNRs? It's a question. I don't know the answer.
Okay. Anyone else have anything? Okay, essentially, what I've written here is that what I mean by clarify is you take those various court cases combined with the CCNRs, and this helps just give everyone what is required by the CCNRs along with the court cases. So while Phil is saying that, oh, you should reinforce it with rebar or have some kind of reinforcement, the CCNRs don't require that. So how can we actually put that in the policy? Does that make sense? 4 inches of concrete will hold your vehicle. Yeah, it's not going to hold if you decide to go pouring maybe somewhere else in your yard, and you run a concrete truck over that. Yeah, you have a good chance of cracking it. A lot of it depends on what's underneath. The only reason I know this stuff is because I worked in concrete for 15 years, so I've seen what happens. Most driveways I ever poured and stuff, that people didn't want rebar or didn't want reinforcement, and for the most part, as long as they're just driving their own vehicles on it, it's not gonna do anything for years and years. Now, of course, if you put a dump truck over it or something really, really heavy, yeah, there's a good chance of cracking your concrete. As far as the level to which it goes, these shoulds that are on here are basically common practices or your general practices of construction. So when you go to put in something, you want to go to the level of, it would be the edge of the road. You're not worried about the crown way out in the middle of the road. You're going to the level of the edge of the road. And so it kind of behooves whoever the homeowner is, they're responsible for putting in the apron. So this isn't the requirement to put in a driveway between the boundary line of your property and the roadway's edge. That's required based on these court cases. So the apron policy isn't adding anything to the CCNRs. It's just, I think, an easier way to understand. The LCA's had an apron policy, and it does nothing to add to the CCNRs. I think it just more helps members to understand, okay, I need to have an apron, and here are the requirements. The requirements, like I said, they gotta be concrete or asphalt. It's gotta be 12 feet wide at the road, and it has to be from the property line to the edge of the road. Those are the requirements based on the court cases or the court rulings. So, and then the other one is should, that's just, those are general practices of concrete construction. So-
Keola, could I interrupt, please? This is Phil. I wanted to ask if you would read CCNR number 10 that you're purporting to clarify. Could you do that?
Yeah, I'll have to bring that up.
I can read it. I've got it in
Okay,
front
go
of me
ahead.
if you'd like. CCNR number 10, driveways. Driveways shall be a minimum of 12 feet wide at the street and shall be paved during or prior to completion of a residence. Then there is a parens, 10 driveways. Driveway is the area between lot owner's home and the boundary line adjacent to the roadway. The term pave allows the use of any smooth surface. Civil number 6865 findings of fact. Does the word apron appear in there?
No,
And the clarification of number 10 states clearly that the driveway that number 10 applies to, it says driveways. It says that the driveway is the area between the lot owner's home and the boundary line adjacent to the roadway. It does not address the area between the boundary line and the edge of the road.
it
Now,
does. It does.
It does not.
It
It does not.
Okay.
Under the courts.
It does. You have to look at the, because when it talks about the legitimate reasons for the board to have it that way, it's in the findings of fact. If I remember
Well,
right.
my point is it hasn't been changed, and I don't believe calling it a clarification solves that problem of 75% of the owners having to approve an amendment to the CCNRs.
You're questioning the 1982, but the 1986 court document is very clear. It states from the boundary line to the road.
Again, that court relied on the assumption that the LCA owned the roads. That's what they were told, and nobody contradicted that. And yet we found out now that that's not true. That changes, I think, significantly the impact of that court's ruling. It was based on false information.
You're saying that, but the LCA was able to litigate this against members and win court cases.
They told the court that the LCA owned the roads, which wasn't true.
The
And it's still
LCA
not
is
true.
still, the LCA is still responsible for maintaining the roads.
Well, but again, if you don't own it, I don't know how you can force someone to improve a piece of land that
Yes,
they
of
or
course,
you
Bill.
don't own.
Okay, so I'm gonna go ahead and move the previous question and go ahead and, if there's no other debate, any other comments?
I have just a question. I personally, when I first read it, I thought it was just fine. I understand Phil's argument, but one is substance and the other is kind of context to me. It seems to me that we all are in agreement that we need to have these aprons. It's simply a matter of, is it a change to the CCNR or not? And I think we can kind of get past that, because I think we all agree we want aprons. And by the way, the other comment that I had, Keola, when I read it, was it said they should be done obviously at the time of construction. And clearly we have people that didn't do that. So that's the other issue that'll be dealt with. And it clarifies in there what the steps are.
Right. Okay, so I move the previous question and go ahead and call a roll call vote. The motion is that we approve this apron policy. Lee, will you go ahead and do a roll call vote?
Is it a policy? Is that what this is
Okay.
actually?
Yes. It's a
Okay.
policy.
All right.
Paola,
Yes.
Jim? Jim,
Yeah, under everything we talked about, I would still say, yes, we need the aprons.
Greg,
Yes, sorry, I
Right.
couldn't get unmuted. Yes,
it's all right. Lee, yes. Mary Ann,
Yes.
Ross,
Yes.
Bill,
No.
All right, the motion passes. It's been approved. So the apron policy will go into effect as of today. All right, I'll turn the time over to Ross about this vetting CCNR compliance.
Okay, so one of the things that has kind of been a problem as for board members, in order for board members to act and to levy fines or anything against homeowners, obviously, we as the board members need to be in total compliance with all CCNRs and so forth. So my thoughts are to have all people vetted to be on the board, that not only our dues are paid, that we are in compliance with CCNRs so that we can enforce CCNRs and be fairly. It can't be okay for the board, but not for the general membership. So we kind of came up with a way to vet them. And do you have something you can put up there, Kayla?
Sure, just 1 second. Let me try to find it. Downloads.
Ross making the motion.
I want
Not
to
yet.
know how it would work.
All right, I'm gonna share screen.
So this is just kind of a timeline of how to do this. And what we would ask is that I be contacted by each person running for the next board. If we as a board currently have any concerns, we would, first, if we didn't have concerns, we would say, no, we have no concerns and you're vetted. If we had concerns, then we would discuss it and we would try and come up with a reason or a way to prove that it was not a concern. And if we found out that what our concern was is not a concern, then no, you'd be vetted. If it still was a concern, we would discuss what actions need to be taken in order to come to some type of resolution. And if we came to a resolution, then fine, we're vetted. If we don't come to a resolution or someone doesn't want to go through this, then you'd be removed as a candidate for the election. Any questions?
Absolutely. I have lots of questions and I'm prepared to go as long as necessary. Will you please name the people you think are in violation and
No,
what they're
I
in
won't.
violation of?
I'm not going to do that in an open forum. You don't discuss people's violations that this person has or that one on any CCNR violation in an open forum. You do not mention names. You do not put people on the spot. And that won't be done. Not going to pit board members or anybody against one another. No.
Is this a bylaw change?
No.
I think it is a bylaw change because the bylaws actually don't say anything about.
All right, you haven't been recognized to speak, Jeff.
Jeffrey, no, Jeffrey, you have to be recognized. The board is not called for comments from the members. If
My
you
hand's
speak-
been raised since the beginning of the
I
meeting.
understand your hand has been raised, and when the forum is open for you to ask a question of the board, you were the first person to be recognized, but you have
They lost
spoken out
the
of turn.
and on anything at any time.
Okay, I'm afraid we're going to go ahead and remove you here.
David, that's very uncalled for. I think all you have to do is mute him.
He has been muted and he has been muted and he's unmuted and continues to unmute. Now, if you're going to be a disturbance to the meeting and if you're not going to follow the policy, you will be removed.
I've only unmuted once.
Okay, well, you can mute again, and when it comes time for questions for the board, you will be the first person recognized. Thank you.
Okay, I guess it's back to me. Ross, I appreciate that, but I think the real concern, and the membership has the right to know, is every bit of this has to do with not an honest vetting of the candidates, but an attack on existing board members trying to run for the new board. And I think that we need to be honest and open about it and be prepared to discuss that.
I'm not going to have this discussion with you, Jim, period.
Well, that's okay. You don't have to have it. This is a board and a board meeting. Who gets to decide?
You have said your piece.
Who gets to decide? Because it may well go to a law firm to determine how these CC&Rs are interpreted. And you're not the position, you personally are not in the position to say, well, I like rule number 5, but not rule number 1 or 10 or 21. So who gets to decide that?
Ross, to my knowledge, has never been about picking rules. He's always been for all the rules.
As by the
Yeah.
way, am I. So I don't have any issue with
What's the
enforcement.
problem then, Jim?
Do
Okay,
what?
so there shouldn't be any issues then, I don't think. The whole point is, obviously, the people in the 70s realized there was an issue with directors being in non-compliance, trying to impose or enforce CC&Rs with members. Seems like a two-way street there. So so it only makes sense that that we're able to vet these things out to make sure that those people coming on the board are in compliance with the CC&Rs.
So what would be some of the, let's have an illustration of what would be some of the potential violations?
No apron.
Pardon me?
No apron.
Okay,
No permits?
No permits.
okay, those are both good.
Dwellings that you have that aren't permitted, undersized dwellings. You have the whole CC&Rs to look at, Jim.
And I have intensely, trust me.
So
Okay.
that's what I mean. Ross would be working off of that. Am I incorrect, Ross?
That's exactly what I'd be working at. That's what I've always worked at. And that's what I've always called out board members for. You can't have one rules for the members and it's okay or something fair for the board members. And that's the reason to do this vetting. And I wouldn't do the vetting on my own. I would definitely have another member or somebody with me if it came down to having an inspection or something like that. It's
And
not
then,
up to me, but it's following the rules that are established. That's it. That's
so,
it. I'm not making
so
up anything.
just to be clear, if someone, for example, says, Jim, you're not in compliance, I have an interpretation and a legal opinion, in fact, maybe 2 or 3 legal opinions, do you think you're in a position to override those?
We'll have to see, won't we? I haven't seen it.
Indeed, we will.
I am not answering any hypotheticals with you, Jim. I'm not going to get into any more argument. I'm done with the talk with you, all right? Over.
Well, no, you don't get to say it's over, and you don't get a chance to get tired, Ross. The
Okay.
issue, folks, I think we ought to have this open and honest discussion. Because again, I contend, that if you eliminate anybody running for the board and don't throw this to the membership to decide, if they think someone's in violation, they simply don't vote for them. But if they do vote, then that person is recognized as long as they're current on their dues. We have 3 separate lawyers that have told the board that. And I think the membership deserves to know we've spent money. We've spent their money to get legal opinions. And
Okay.
we can't have somebody on the architectural committee simply throw those out at a whim and say, I don't like you, therefore you're not in compliance.
Okay, Jim, unfortunately, apparently these lawyers didn't know that there was a CCNR or not a CCR bylaw.
That's bullshit. It's as plain and simple as that. Are you telling me that you're smarter than 3 lawyers? In
No,
addition,
all I'm saying is that they weren't aware that
it
that there was
doesn't make
actually
any
amendment.
difference. You are reading something from 45 years ago and trying to say that relates today, and it doesn't. And by the way, I'm not against the CCNR since I'm in compliance with the CCNRs
Okay,
and
then
can
what's-
prove I'm in compliance.
What's the problem then?
There isn't one if it's related to me. If it's related to other people, depending on what it is, I would call attention to the Senate bill passed just last year while you've been in office and the House bill passed in 2020 to make sure that you all understand the implications of this on other members. And if you're not familiar with these, I'll be glad to provide them to both you and the membership so they can see what's allowable and what isn't allowable by law. And as you said so many times, the Senate rules override, or the state legislature overrides any HOA rules. And I don't think that we've ever discussed, nor have we got an opinion on HB 2620 and SB 186 HD1.
All right, you email me those references? Or
I'll
those-
email them and also suggest that we have an attorney review them because they're applicable in my opinion, but I'm not the lawyer.
Okay, any more debate? Ross, where did Ross go?
Went to the bathroom.
I'm sorry, I have other things too.
Yeah, so I can't remember. Did you put forth a motion, Ross?
I
No,
make a motion that we proceed to vet all candidates as shown in the chart.
Any more debate on this? Okay, Lee, will you call roll call vote? Lee?
Uh-oh.
I think we may have lost Lee. Oh, wait a minute. I see him there. He needs to unmute.
Kayla,
Yes.
Jim,
No,
Greg,
Yes.
Lee, yes. Mary Ann,
nope,
Ross,
Yes,
Phil,
No,
Okay, the motion carries. Candidates will be vetted as toward CCNR compliance as was discussed and shown on the vetting chart. All right, moving on to the next thing, discussion about special assessment. So I don't even know necessarily where to lead this discussion. But there, we have to at least think about whether we are going to, I mean, basically the SBA loan was supposed to have had a special assessment. That was the only way that the SBA was going to allow that. That did not happen. So, what's anybody's thoughts about that?
Keola, this is Phil. If I can start out, please. First of all, I think it's pretty clear to anybody that looks at HOA governance that our finances really should be done on a budgetary basis. We need to know where our
Special
money's
assessment.
coming from, and we need to know where it's going. Our history of dealing with budgets has been atrocious. There was never a budget until I created one last year, and unfortunately, it's essentially been ignored. I'm afraid that that situation is going to happen again. We are going to encumber our association with a huge debt. And I think I would encourage and implore this board to not take that step until we have a budgetary basis. I want to know what this money is going to go for. I think I already know that. And I want to know how we're going to pay it back, where the money's going to come from. How are we going to cover our basic expenses that we have every month? How are we going to fund a reserve fund? We don't have any idea even how much we need in a special assessment. So I think that it's premature to vote on a special assessment at this point. I think we have a lot of work to do to establish a budgetary basis for this. And I think we need and owe it to the members of our association to do that before we spend their money. Now, I'm not opposed to a special assessment. I think clearly that that is the way to solve this financial dilemma that we're in. However, again, I would reiterate my plea is that we do it on a budgetary basis, that we spend the time that it takes to create a budget that's real and that we're willing to follow. Thank you.
Right. Well, I didn't call for any vote on this evening. All I asked was for discussion. So, and then as far as budgets are concerned, I know that whole talk about there not being budgets in the past is actually erroneous. I, after reading through the minutes of the LCA, almost maybe in recent history that's the case, but definitely back all the way up through at least what I saw. I read through 2002 and some into 2012. Almost every year they had a budget. So I think it might be more recent, like within the last few years, that we haven't really seen them. But I know Greg says that they had budgets when he was on the board previously. So it might be more of a recent history type thing, I think. Anyone else about
Yeah.
anything
My
about
thoughts on it are, since we have to go ahead and we have to pay Glover one way or another, I don't think that going with Bank of Hawaii or anything is in our favor. It's just going to cost us more money. I think that we need to be, we should look at what the, almost like what the terms were with maybe the SBA for some guidance, and even with Bank of Hawaii, what some of their terms were, and that we ought to determine if we can make those payments back to ourselves without the special assessment. But if we see that it's not possible to make those payments back to regain what we're spending, then obviously we would need to do a special assessment. But I think we should definitely immediately after paying off Glover, we need to come up with a way that we're going to repay the association, and just as we would be paying off any other debt to anyone else. That's just kind of my thoughts on it.
Well, I think we already voted to spend the money out of the, unfortunately, the existing accounts, even with penalties. But your other comments, I think, are valid, as are all of Phil's comments. We need to come up with a budget, adhere to the budget, make it an inviolate deal to where we build reserves back, as opposed to rob Peter to pay Paul, which is what we're having to do today. So with that in mind, I also, if need be, would be pro an assessment. However, the only caveat to that is it's our understanding, I think, at least the board's understanding, that there may be a second round available from the county, whether that's Eileen or Greg's offered to do that under Neighborhood Watch. But if we could come back up with the 350 or so thousand we got in the last time, that puts us right back into comfortable position. So we need to.
That would be great. That would be great.
we need to try and determine as best we can, maybe Greg can help us out here, if and when we think that might happen before we slap all the members with an assessment.
I already contacted the county and told them what happened, and they're going to keep me updated as to the second round.
And
Any-
even if an assessment was deemed necessary without that, Jim, and then we were able to get that, we could rescind the assessment. We could put wouldn't have to go through to the end on it.
Well,
So-
that's something that needs to be discussed, because if we believe at all, the last board, they said that eventually we're gonna need $4 million to update the roads. And at any rate that we could budget or assess, we're not ever gonna have $4 million. So if in fact we get the other loan and we've already assessed and come up with, I don't know, 50, 100, 150,000, that would be awful nice to just make sure that goes in to the cushions. So it's something we can
course.
discuss.
Everything that was collected, we would keep as our reserves. But we could stop a special assessment if we
Yes.
got another one. We wouldn't have to saddle the membership with a continued special assessment.
Agree with that comment completely.
I think we have time to wait for what's going to happen with the second round to make that decision. I don't think we need to make a special assessment decision right now.
Yeah. Yeah, there's more. I just want to discuss it a little bit rather than make any decisions about it tonight. Okay.
And by the way, I think it's important to point out, the reason we're in this position, other than all of what Greg said, which is factual about the SBA loan, is we made a decision, the current board, based on the fact that we fought. And so we operated in good faith, thinking we were going to get the SBA loan until the new lady came in, or the new person, and denied it. Otherwise, we would have only done partial Grover or Glover construction as opposed to all of it.
Right. Okay. Anything else from the board? Any new business?
New business?
Yeah, anything come up? We want a new business? If not, we'll go ahead and open up for questions from the members and comments. Mary Ann?
Well, I was
You
going
got
to say under new business, I would really like to make a motion to hold the elections and annual members meeting March 26th. And I know that's a hopeful date, but I would think it's important enough to put a tentative date out until we get a judge's ruling.
Okay, Mary Ann has moved to put out a tentative date for the election to be, would you say March 26th?
Yes.
The floor is open for debate.
As a precedent, we've had 50 straight years of the election in March. Even though the CCNR said, or whatever said it should have been in January, we all know it was moved to March, and it's been consistent in March for 50 years. So I agree, and I support Mary Ann's motion.
Anyone else want to debate?
Well, last meeting, we decided we were going to wait for the court ruling, so I think we should wait instead of spinning our wheels as usual.
Keola, this is Phil Denny. It seems to me that given the documents that we have to look at, the election can only be on one of two dates. It either has to be third Thursday in January, correct me if I'm wrong, according to the original documents, or it has to be the third Saturday in March, as it's been done for the last 50 years, and which the suit says was improper. So I don't understand how it could be any other than those two dates. Therefore, it seems to me that going ahead to schedule the election for March 26 makes perfect sense. Now, if the judge's ruling comes down beforehand and says something different, then we can always change. But I think that this is important enough that we should not delay it. one could make the charge, and again, please don't hear me making the charge, but one could make the charge that the reason that you are delaying the election is to further the suit. And if that is in fact the case, that clearly is a conflict. Now, again, I'm not suggesting that's true, but I'm thinking that it gives the appearance of that. And I think the appearance of impropriety is important. Now, again, I think that having this election also includes having the annual general meeting, which in my opinion may even be more important. And again, as you well know, the members, as opposed to the board, the members at the annual general meeting have the right to conduct any business. And I think it's clear, at least it is to me, that whoever is elected to the new board, the majority is going to be opposed to the lawsuit. So again, it calls into question the potential impropriety of delaying this process for the benefit of the original plaintiffs of the lawsuit. So I would very much encourage this board to do the right thing, to schedule the election on the 26th, even if we have to have a two scenario process. I think we need to have the candidates forum as scheduled. I think we need to mail the ballots out. I think we need to just to move ahead with this process and show our commitment to good governance. Thank you.
Okay, thank you, Phil. Anyone else? Okay, yeah, the only thing I would say is, I believe it was November, that we approved just waiting till there was a ruling. And that's basically where I stand. I mean, it's not to further the lawsuit, it's to have a clear path and direction as to what to do based on the ruling.
I think Phil's comments allowed for the fact that we schedule it, and then if we don't have a ruling, it can be delayed later, but at least we can get it on the calendar.
Okay. Anyone else have any comments?
The idea of a 2-option ballot thing going out, everybody's going to be so damn confused they can hardly keep it straight when there's one single ballot going out. So
But have you seen it?
Was there one? I don't know. It seems to me if it was, the whole board should be aware of it.
I think Mary Ann's prepared to share that.
Yeah.
Well, why wasn't it brought to the board before? Or you three working your own?
It wasn't ready. We're doing this process. Greg, Phil Denny, Mary Ann Farrell, we were assigned to manage the election for 2022. That's what we were assigned, and that's what we've done.
So we've done a lot.
We've done a lot of work.
On the agenda tonight to explain to the board and have a vote on it instead of you guys moving ahead with it. You even posted it on the website.
We didn't post anything. What we did is we gave a work in progress report to somebody that asked, and no one else on the board would answer. That's what we did. We haven't approved or gone ahead and done anything. What we're doing with this motion tonight is to deal with this. And that's what the motion is, to have the election on the 26th and to deal with it. All of this stuff is going to be brought before the board. None of this is secret, Greg. We're not doing anything behind anybody's back. We're just doing what we were asked to do. Thank you.
Excuse me, but
Go
I
ahead,
am
Lee.
the board member that is responsible for the website. Did anyone ask me or even include me on any emails or communications?
About what, Lee?
About anything about the election?
It was prematurely. We're not done. We're in the middle of doing this. And then this
But stuff got put on the but stuff got posted on the website. Richard did what he thought was correct, and yet he thought the board was in favor of this, but it was not. Am I correct?
I
We
missed
don't
the-
know. We don't know. We're having a motion. Let's vote on the motion and find out.
Okay,
I
I
think
missed.
I think the
motion
rest of the
because
board
I
didn't even
dropped out.
know.
That we were working on the elections?
No, about the
No.
forum. I didn't know
Oh,
until I saw.
we're
the
talking about two
website.
different things.
Oh, okay.
Candidates forum and elections and annual meeting, two different things.
Right,
So that's
so
what
this should
we're
be,
clear
we
on.
should be discussing the election.
Correct. Thank you. Yes.
There any other comments? Okay, so the motion was that Mary Ann put forward was that we move ahead with an election date of March 26th. Let's see, Lee, will you go ahead and do a roll call vote?
Bill,
No.
Greg,
No,
Lee, no. Mary Ann,
Yes.
Ross,
You're muted, Ross.
No,
Bill,
Yes.
Was that everyone?
No,
Okay, yeah, you forgot Jim. So
I
thought-
say,
oh, I'm sorry, Jim.
the answer is yes.
Okay, the motion does not carry. Okay. That we'll go ahead and open up for questions for the board from the members. David, will you go ahead and
Yeah, okay. So we're starting the 15-minute period that's open to members for questions to the board. Each member gets 2 minutes to state their question. Once they've stated their question, then the board can answer as they choose, and then we'll move on to the next person. So we'll go ahead and start with Jeffrey's iPad. Jeffrey?
Yeah, I actually have 7 questions. And I would like to point out that if you have 15 minutes, that only allows 7 members to speak, and there's 2,006 members, so that's pretty disproportionate. So question number 1 is, if the current board members are going to vet proposed board members, shouldn't the current board members also resign if they have CCR violations, which almost all current board members do have CCR violations? My second question is, where in the bylaws does it say that CCR violations can be used to exclude members from running for the board? Okay, my third question is, the LCA operates on accrual accounting. So if we operate on accrual accounting, why has it taken so long for the invoice for legal fees to be posted? There was discussion in board's meetings several months ago that the invoice was received. Under accrual accounting, when the invoice is received, it should be posted immediately. Question number 4, how are we going to enforce the apron policy? Is a board member going to inspect at the time of construction to make sure that it's 4 inches deep and that the proper material is used? Has anyone thought about how we're going to enforce that? Since there appears to be no way to enforce CCRs, period, by any board or any member. My 5th question is vetting. I consider the vetting to be a change in the bylaws. It doesn't say anything in the bylaws about vetting members, so that would be a bylaw change and is therefore not legal. It could be attested in the court of law. The second thing is a special assessment. One thing you could do immediately to avoid a special assessment is just do a dues increase. You can do 10% a year. And also all the lava covered lots, you could just have them pay dues again. And that would increase the money brought in and would probably avoid an assessment. Okay, and then my third term is if the judge does make a ruling in the lawsuit, he's not going to rule that there won't be an election. Really, the only thing that the judgment is going to be is whether the 2-year terms were legal. And then possibly the date of the election. We still have to have an election. So postponing the election is not in anybody's interest and is probably not legal. Also, the terms expire after 1 year. So as of the 31st, the date of that meeting, we won't have any board members. Everybody on the board, your terms will have expired.
Okay, thank
so
you, Jeffrey. Okay, Jeffrey has asked a few questions. Board can choose to answer.
Are there any board members who choose to answer? Any of those?
I can answer about the attorney invoice. We just got it, so that's why it hasn't been on the books.
But there was discussion in meetings 3 months ago
Okay,
that.
yeah,
invoices-
you've already
You've been
spoken.
muted.
So
Yeah,
there was
go ahead.
discussion, but that doesn't mean we actually had an invoice at that time. There was a number that we were given. That was actually considerably higher, I think. I think it was like $36,000. So, as-
Keola, as you recall, we did get an invoice, but it was questioned as to the appropriateness of some of the charges, and it was sent back. And that was a number of months ago. And then this most recent one that we've just discussed tonight was just received within the last few weeks. Is that correct?
That's correct.
Yeah, okay.
So I'm trying to think of the other questions. Aprons, well, as far as aprons are concerned, previously in the LCA, they, I mean, that was enforced throughout the years in the LCA, so I don't know. To me, that's just, you see someone that doesn't have an apron, then that's a violation. I'm not certain. I mean, like I said, the apron policy just kind of outlines what's required, at least by from the court cases and from the CCNR. But like I said, on there, it should be 4 inches and should be, because it's not a requirement based on the court rulings or the direct text of the CCNR violation.
Aprons have been replaced over and over again when people have made them too thin. So if you skimp on it, making it first time, you'll have to redo it sooner.
Yeah,
That's-
so it's
that's
really,
history.
it's better for of course, we can't go and measure how thick it is. Well, you kind of can from the side, but
Will,
it's really left up
Keola-
to the member to, yes, to
Keola,
do that.
will the existing aprons be grandfathered in, or will people have to tear them out and redo them?
Well, as far as the apron policy goes, it says at the time of installation, because we know the pavement can be added on to, and so of course you're gonna have aprons that are gonna be lower than, and that's lower than the road, and that's no fault of the homeowner if they put it in right the first time. As long as it's not in disrepair, I don't see any issue with it. They have an apron.
Okay, but the previous policy said it was 12 feet by 4 feet, not 12 feet by 10 feet.
We're not worried about the
is-
previous policy right now, Phil.
Well, but many people have put in aprons that have followed that previous policy and now will not be in compliance.
No, that would be hard to determine as far as wherever the boundary line is. I don't know that I'm gonna go around checking to see where a person's boundary line is.
I see. So again.
But the apron is essentially there to protect the roadway edge.
Right. Thank you.
All right, is there any others? Then I'll go ahead and move on to the next member. Pete, you can go ahead and unmute and ask your question of the board.
Before Pete does that, could I possibly say in Jeffrey's case,
Wait, Jim, he's talking. We just can't hear him.
He's unmuted now. We should be able to hear him. Pete, can you hear us? I show him as unmuted, but I don't hear him. Pete, can you speak up once you get your audio handled? So go ahead, Jim.
I just wanted to say in Jeffrey's case, I you know, I think we're all pretty competent, but I don't remember all 7 questions. So Jeffrey, if we didn't get to a specific question or two, you can either bring it up next month or submit it in writing and get on the agenda to have those things addressed. So if we apologize if we didn't get to some of your items.
Okay, let's try Pete again. Pete, can you, is your audio working? We're trying to hear you here. Okay, I'm sorry, Pete, no one can hear you here. When you get your audio resolved, please speak up again. We'll recognize you. So we'll go ahead and move to the next member. The next member is Daryl. Daryl, please unmute and state your question for the board.
Okay, can you hear me?
Yes, we can. Yes, we can.
Okay, so my question is for Greg. Once Glover is paid, what is the balance as of today in the LCA accounts?
The financials are posted on the website. I mean, I can't tell you exactly what it is today because we haven't got the balance out of the account yet. So
That's not an answer. What is the balance as of today, once you pay Glover?
The board gave you their answer. Daryl, thank you for your question. Next, let's see, we have Rod. Rod, go ahead and unmute. Rod, please unmute.
Yes. Concerning the next election cycle, the forum, the nominations, as our bylaws are right now, thanks to the 2019 Board of Directors, we are on a even number year, which means there are 3 two-year positions. Under that scenario, that's how people decided they wanted to be on the board or not on the board. If you change that, or the lawyer changes that, or the courts change that to 7 one-year terms, then we've cut out other members of the community in good standing who would like to serve on the board for 1 year, not 2 year. So if it happens to change, we need to reopen the nomination process for those members who have been disenfranchised. Thank you.
Thank you, Rod.
Okay, if there's no response from the board, we'll go ahead to our next member, Mark Ellis. Please unmute. You can state your question to the board.
Hey, thanks. Am I coming through okay?
Yes, you are.
Great. Couple quick comments. I wanted to thank Michael for the job he did a month or so ago, removing a fallen albizia from Pomaikai that I reported on Neighborhood Watch. I think Jim passed it on to Michael, and when I went by the next morning, that whole rascal was gone. So thanks for jumping right on that, guys. And then Ross, regarding the Malama Luana house, there are at least 10 junkers on that property. One way to attack that would be the county only allows, the zoning only allows 2 unregistered vehicles on the property. And that place is stacked with them right now. And also the car in the driveway, the trunk, the rear end is right at the road. So I would think the police would pink slip that rascal, because it's, you know, it's protruding to the road. It's certainly not on the property. It's on the county prop. Well, it's not on the house property. It's on that buffer there, whatever that distance is, 12 feet, but it's right at the road. So, and this has happened really recently. This just total accumulation of junkers.
Okay, well, that's already been discussed.
What's the question?
All right. One question is, why do you have to wait for a judge's decision to hold elections.
Okay, thank you, Mark. The board can respond to that if they choose.
Well, at least in my view, it offers a much more clear path as to what we need, what to do. Like I said, we have bylaws that are in question. So we don't know if it's 2 years, a 2-year term or a 1-year term. And actually what Rod brought up, I hadn't even considered that people that put in their nominations, you know, according to what the bylaws that were changed, it's very possible they were considering 2-year terms. And for those that may have thought that it was a 1-year term, or if there was that opportunity that it was only a 1-year term, then maybe we do need to reopen nominations. I don't know the answer to that question. And so I personally feel that there is a clear path going forward by waiting for the judge's ruling.
I would think that, well, first of all, if the judge rules that.
Mark, you've asked your question. Thank you very much.
Have I finished my 2 minutes?
Yes, sir, you did. You might have heard my alarm going off when you were
Wow.
finishing the last of your question. Sorry.
That's just my answer. So,
Okay. So let's go ahead. We'll go to the next member. Richard, you can go ahead and unmute, ask your question of the board.
Okay, mine are more comments than questions.
Okay.
I'm getting feedback somehow or another. So I guess I did post the candidates forum on the website for actually Saturday week from now. So there wasn't any discussion about that in the meeting. So is there going to be a candidates forum on the 17th of February or not? So that's one question. And then aprons policy. I understand the aprons policy and I agree with the aprons policy, but there are at least 36 existing properties that were developed with no aprons. So what happens? Do those people, I mean, are they grandfathered in or do they have to create aprons because they never created aprons?
yeah, sorry.
And then I shared Daryl's comment or question about, I'm concerned that apparently we're going to wipe out all the cash in the LCA accounts to pay Glover this month based upon the balance sheet. But I do realize that we have the 2022 invoices that just went out. So we will have money coming in, hopefully in February and March, hopefully enough to cover our expenses like payroll and just basic monthly expenses. So I agree with Phil in terms of budgeting. I mean, I don't have a clue, you know, do we have enough money? Or are we going to like wipe out the accounts and then be bankrupt or something? So my questions, again, is there a candidates forum on February 17th? And what happens to the 36 existing properties with no aprons?
Richard, can I answer you about the candidates forum?
Sure.
It's on the 19th. And for me, it is just as much a meet and greet because there's some candidates I don't know. And yeah, as far as I'm concerned, the forum is on with the help of our community members and just need a timekeeper. That's about the only other helping. There's 7 or 8 people that are helping.
Thank you. So my error is the 19th, is Saturday the 19th, but we posted it from 4 to 6. Do the candidates know there's a candidates forum?
I don't know that. I hope
Thank
they
you,
do.
Richard.
So that is a good question. How do we know that all the candidates have that information?
We don't know that yet. I mean, I'm kind of waiting for tonight's meeting to move forward with the tentative ballot, election ballots, anything. I was kind of waiting for tonight. So after I know, hopefully we could have our office manager email the 13 candidates or however that ends up being according to Ross.
Yeah, because the problem with that is that you may have some candidates that already have plans for next weekend if they haven't already been informed. Is the
Mhm.
problem.
You're right, sure, sure. It's a meet and greet as far as I'm concerned.
Okay, and then, you know, the question I posed was, how do we make sure that it remains unbiased?
How does it remain unbiased?
Yeah,
I don't know. We have questions asked by the people.
okay, is
The
that
candidates, we have an
kind of,
expertise.
so is Dane's gonna,
He was willing, yes, he was
so
willing.
he's gonna do it?
Yeah, yeah.
Keola, this is Phil Denny. It's been posted on the website, and whichever candidates choose to come and meet their constituents, I think that's fine. I don't think there's any requirement that every candidate show up. It's been posted. Everybody's had an opportunity to know that. I don't see any requirement. We got to send people, registered letters or anything.
Well, I see a problem if you haven't contacted all the candidates to give them that opportunity, if that's what they want. That's
Well,
the problem I see.
we posted it.
Okay, so you posted it, but you gotta make an effort to get a hold of them.
Okay.
You
Well,
can't
if it's-
just post it and then just hope they see it, is what I'm saying, because you want every candidate to have the opportunity to come out and speak. But if you haven't made the effort to get a hold of them, not everyone, like we know, not everyone goes to the LCA website like we would encourage them or hope that they do.
Absolutely right, Keola.
That's how the rest of the website works, is that if you happen to go on there and look at it, you get informed. And, there's no newsletter. Nobody sends me anything in the mail. If I have to be informed, I have to go to the website. How else am I going to be informed, Keola?
Again, I see your point, but if you're in control, if you're the one doing this, I would hope that you would think to get all the candidates there.
That would be ideal. You're absolutely right.
Right, so that would mean making contact with each one of those candidates. That
May
you
I
know you made
request-
contact with them.
May I request our office manager email the 13 candidates and let them know either they can show up or not. I just think it's an important,
Okay, so who's in charge of it?
Who's in charge?
who's in charge of what?
This forum?
Or is there anyone in charge? I think it's an important thing. Myself and Phil were in charge of elections. I think it's an important thing. And if people want to come, they can come. And if they don't have to.
Okay, so
Ross has to
who's
do
in
his
charge? That's my
Me.
question.
Me.
Okay, so Marianne, will you
Yes.
make sure you contact every candidate so that they know that there is a forum? And if
I would
they're-
love to, Kale. I don't have their emails. That's why I'm asking the office manager to do that for me. I don't have all
It
those.
should be a Zoom forum.
Pardon me?
Daryl,
It should be
Daryl,
hosted on
you
Zoom.
need to mute.
I agree.
Daryl.
If you would be willing to Zoom it for us, I'd be happy. I don't have that skill. So I'm just looking for anyone to help with this. I need a timekeeper. And if you can Zoom it, great. I don't have that ability.
So the board puts on the form now.
Yeah,
Okay.
like I've said in the emails, I really don't think the board this should be a function of the board. But
It's not, it's my,
because it was started by members as a way to get to know the candidates and remain somewhat aloof from it, I believe. David, go ahead with.
All right, we'll move on to our next member, Mark Juanillo. Please unmute and ask your question.
I move. Okay, is the current due 110 still? Do we pay the special assessment?
There's no special assessment, Mark.
I received a letter and it says $200 special assessment.
Greg.
Or is that the due?
I think it's the due. I think there was some mistake on the outgoing billing. Greg, you want to address that? Greg.
I'm sorry, I missed, what was the question, Mark?
Do we still pay the dues at 110? And I receive a bill, special assessment of $200. So do we pay that also?
That's the annual assessment of 200. It's not a special assessment. That's the annual fee. It's been that way for, this is the 3rd year.
Okay, reason why I asked because the previous board had elevated that the yearly dues to 200, and then that was one of the issues that the board now had with the previous board. That's why I asked this question.
Yeah, no, we took it. They had increased it again to 220 and we reduced it back down to 200.
Oh,
Yeah, and that was part of what's in the litigation is whether that the other side still contends that they did it correctly. And so just like the bylaw change, there's still that contention about
Okay.
whether it was done correctly or not.
All right, thank you.
All right. Thank you, Mark. So we have Pete Wilson. Pete, can you unmute and ask your question of the board?
I don't know, can I unmute?
Yes, you can. It looks like we
Okay, I
can hear you
did.
fine.
So first off, I object to you because you weren't appointed and I don't need a sergeant at arms to tell me whether I live or breathe.
Okay, that's,
And secondly, you don't interrupt me. I got 2 minutes. And secondly,
yes, we can interrupt you.
well,
Okay,
sir,
he's been
are you in
appointed.
Houston right now? There's another question. And are you still a president while you're in Houston? But I got another question.
Okay. We have one last member that would like to speak. I have Ann or Mick. I'm not sure which one it is. Whoever is the spokesperson for your group, please unmute and ask your question.
This is Ann Calver. I wanted to know how many positions were available or open on the board. How many directors' positions are available, and who, if any, are staying on the board?
Is that it?
Yep.
We
Okay,
don't know.
That
don't know.
is critical to this ruling. That all that is, this ruling will help us to know what that answer is.
How many, if it's, how many would stay on if it was ruled that they were 2 and 1 term positions?
There would be 4 people that would stay on.
And who would that be?
Me, myself,
elected.
Greg, Mary Ann, and Jim.
And would you be staying on if that so comes through? How many will be staying on?
I'll be on.
I can't answer that right now.
I'll be on.
And this is Phil Denny. If I could just clarify just a little bit, there's 2 scenarios here. The one scenario is, as we've done it all along before the bylaws change, is 7 directors would be elected each year. That's one scenario, 7 out of the 13 candidates. The second scenario is if we follow the bylaws as they've been changed, this is an even year, and 3 board members will be elected for 2-year terms. Those are the 2 scenarios. Those are the only 2 possible scenarios. If the second scenario is followed, the 4 board members that were elected in the odd year, which was 2021, which would be Keola, Jim, Mary Ann, and Greg, would stay on for another year. If any of them don't wish to serve their second year, they're free to resign. And so apparently, as we voted, we're waiting for the judge to decide which scenario is going to work. And apparently, we're going to delay the election until that happens. I hope that helps.
All right, Keola, we've reached the end of the 15-minute period and all members have been recognized.
Okay, thank you, David. So, obviously, we're gonna go into executive session after this meeting. So I want to thank everyone for coming out. And I just want to say, as it relates to the financial aspects of the road project, just want you to know Greg has poured in a lot of effort and time into trying to
Rescue.
to find a way to rescue how we were to pay for the roads without drawing from the reserves. He was constantly working through obstacles as he worked through this, and eventually come up against an obstacle, couldn't get around. And so thus it's come down to where we're at. It not really any fault of his. It has to do with those that before him. And in my opinion, if there's anyone that epitomizes Leilani and what it is, it's Greg Armstrong. And I don't think anyone works any harder than he does for the good of the community.
Yep.
So with that, I move that we adjourn this meeting and reconvening executive session. All those in favor say aye.
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 Any opposed? Okay, the ayes have it. This meeting is adjourned.